All right, our next case is 231354, Michael Waite versus State of Florida.
Thank you. May it please the court. My name is Sarah Roberge, and I am with Brannick Berman and Sider, and we represent Mr. Waite, the appellant in this case. There are two main issues in this case. The first is that the wiretapping charges fail because there's no reasonable expectation of privacy. The second is that because there's no wiretapping charges, those fail, there's no probable cause for the arrest, and the arrest charges fail. There's no objective, reasonable expectation of privacy because society refuses to recognize it, and that is fatal to the state's claim. Based on the undisputed facts, these officers were working in their official capacity at every opportunity that Mr. Waite recorded them. And because of that, they did not have an expectation of privacy that would be recognized by society. That comes from our Sunshine Law in this state, that all government records are disclosable to the public, and there can't be an expectation of privacy that records that are disclosable by law to the public would be private. Also, under cases like State versus Foster out of the 4th DCA, there's not a reasonable expectation of privacy when there is a discussion of officer misconduct. And under State versus Inciarano, it makes it very clear that there are two aspects to having that expectation of privacy: the subjective expectation of privacy and the objective one recognized by society. Finally, the First Amendment, there is a First Amendment right to record officers, and there cannot be an expectation of privacy in a situation where Mr. Waite is exercising his right to do something that he is allowed to as a First Amendment right.
For the First Amendment, I think your opponent pointed out those cases all deal with public places, people videotaping what's going on the sidewalk or something like that, whether it's videotaping or audio recording. Is that correct?
Yes, Your Honor. That is correct, but again, it doesn't really change what we're talking about here. I think State versus Foster out of the 4th District Court of Appeal does a very good job of explaining how it can be. So in that case, it was a Department of Corrections case where there was an officer on Department of Corrections property where there were signs posted that there are no cell phones allowed. However, that officer recorded his exit interview because he thought that it would not be properly reported, and he was talking about other officers injuring inmates. And so later, Foster is the defendant in that case. She did actually falsify the reports and tried to have that excluded, but the 4th District held that that was not an oral communication under the wiretapping statute because of the public importance. And that's what's happening here in this case as well.
Well, the Morningstar case seems to kind of state as a blanket that you have no reasonable expectation of privacy in your office, right? Correct,
yes. And I think also Average also has that same idea where they're talking about when you're talking on a business line that there is no reasonable expectation of privacy. That's recognized in the harassment statute was that case. So yes, and these officers were all performing their official duties. They were all talking about police business. Moving on to the arrest charges then, the arrest charges, that was a problem, prosecution was a problem from start to finish. As we've already discussed, the charge was completely defective. And
Can I go back to the wiretapping issue just to focus on that while you're...
Yes, Your Honor.
There was audio tape done by Mr. Waite, correct?
Yes.
And there's audio tape for the 911 call that the state recorded. Is there any other state recorded conversations?
Not that I'm aware of, Your Honor.
Okay. Now, if Mr. Waite had called up an officer who in off-duty time has yard maintenance, he calls him up and records that conversation with the officer who's not performing a public function, he's doing a side job, doing some yard work or whatnot. He clearly doesn't have an expectation of privacy in that phone call. It couldn't be recorded. The officer who's now working in a private capacity as a yard maintenance guy.
No, he would have an expectation of privacy.
Okay, that's right. So your whole argument is that simply because the call from Mr. Waite to the police station, to the police officer, was during the time he was working, that ipso facto turns it into a public forum?
Yes, Your Honor. Yes.
Even if the officer is sitting in a private office and the call is initiated by Mr. Waite, and Mr. Waite put aside the fact that there is some evidence that Waite said this will be recorded previously, even though the fact he did not tell the officer, I'm recording this phone call at this time.
Your Honor, we would say that yes, when an officer is acting in his official capacity, that is a public conversation. That's, again, from the Sunshine Laws. And I think that, again, going back to State versus Foster, that 4th District case does really show that when you have situations where officers are performing their official duties, that there is not a reasonable expectation of privacy.
What does the federal law say about recording of conversations without all-party consent?
Your Honor, that wasn't an issue in this case, I don't think, and I'm not familiar exactly with what the federal...
Okay, last I knew that any call, like say between Florida and Georgia or some sort of, where there's a federal connection involved, interstate commerce and so forth, there had to be a beep tone of some sort. There was no beep tone on these calls.
That is not as far as I'm aware, Your Honor.
Right.
Yes.
I have a fact question for you to make sure I'm understanding the sequence. At some point, Mr. Waite called into 911. He wanted to get a case number or something like that. The 911 operator said he or she would have somebody call him back, a deputy call him back. And Mr. Waite said during that conversation with the 911 operator, you know, I'm going to record all these calls. And the 911 operator said, that's okay, you can do it. And he says, I'm going to do it. And the operator again says, that's okay. After that is when Sergeant Blair returned the call to Mr. Waite. Is that right?
So immediately before Sergeant Blair returned Mr. Waite's call, Mr. Waite had actually left a voicemail for Sergeant Blair that said this call should be recorded. And then when Sergeant Blair called him back, he did record that call.
Was that on the same day as the 911 operator conversation?
I am not entirely sure of that, Your Honor. I don't believe it was on the same day.
All right, thank you.
So the arrest charges were a problem. The prosecution was a problem from start to finish. And so the charge, as we've discussed, was completely defective. And part of what happened there was that Detective Chenoweth did not know all of the information he needed to know. Sergeant Blair never told him about the voicemail that Mr. Waite had left for him. And so when he brought that information to the state attorney's office, he was missing information. And that is an omission that would defeat probable cause for the information and later for the capias. That is further exacerbated by the fact that Detective Chenoweth then went to the judge who issued that capias, and that same omission was repeated. And under the fellow officer rule, which Whiteley versus Warden out of Wyoming State Penitentiary, that's a Supreme Court of the United States case, any information that is known to one officer is imputed to be known to all the other officers in the investigation. So the fact that Detective Chenoweth may not have known really is irrelevant. The fact is that that information was imputed to be known to everyone. Because there was no probable cause for the arrest, that arrest was illegal. And so because the arrest was illegal, all of the evidence that was pertained relevant to that arrest or from that arrest should be excluded per the suppression motion that Mr. Waite argued.
And counsel, if we could just talk about that suppression motion quickly. That was with respect to the 4 charges, because there were only 4 charges at that time, is that correct? The 4 wiretapping charges.
So the suppression motion went to, yes, it went to all of the evidence that was taken from the recorder that was incident to his arrest, as well as to the arrest charges.
Okay, and there was later a 5th charge added, is that correct?
Yes, it was. And I believe that the state agreed that that was to be included in the dispositive motions and that it should have been included in that.
Okay,
Yes.
Thank you.
Furthermore, because there were omissions, the good faith exception of the exclusionary rule does not apply in this case. Normally, you can have a good faith reliance on a warrant, but in this case it doesn't apply because there were omissions because of the misconduct in the case. Following the arrest, there was a failure to preserve evidence. And In this case, the evidence was material. If we look at Mordenti versus State from the Florida Supreme Court, evidence that goes to credibility is material when the case really rests on testimony here. And in our case, all of the testimony or all of the evidence that would have gone to proving the state's case for the arrest charges would have come from testimony from the deputies. And so their credibility is a material issue in this case. And there is a duty to preserve evidence. State versus Hills out of the 4th District recognize that there is that duty to preserve. And part of the reason for that is the idea that if there is no duty to preserve, then simply officers could fail to collect evidence or preserve evidence and then get around the Brady requirement to disclose it. And so that was a violation of Brady in this case. Any one of these issues alone would have been sufficient by itself to overturn these charges, but when we add them all together, it is a gross violation of due process. We have several cases from the Florida Supreme Court that talks about that misconduct, especially egregious misconduct, by the government cannot uphold a conviction. So we have State versus Glosson and State versus Williams. Those are the 2 Florida Supreme Court cases. And importantly, a violation of due process does not require threats or acts of violence. And so egregious misconduct, essentially where the government breaks the law. And in this case, we have that because we have violations of Mr. Waite's rights, civil rights, starting from the very beginning. And so the government can't sustain a conviction when there is egregious misconduct like that.
When you're talking about a conviction and these charges, are you including the charge of battery on a law enforcement officer and resisting with violence?
Yes, Your Honor.
So you're saying those 2 should be dismissed as well?
Yes, Your Honor.
So you're saying that if there's some flaw in an arrest warrant, the defendant being arrested can beat on the law enforcement officers to his heart's content with no consequences?
No, Your Honor, that is not what we're saying. But what we are saying is that there was a fatal flaw in the beginning from all of this.
I understand that.
And so we have, for instance, out of the 2nd District Court of Appeal, the Brown versus State and the JW versus State cases. And part of the requirement for a battery on a law enforcement officer charge and the resisting with violence charge is that they be acting in their lawful duties. And the 2nd District found in those 2 cases that because they were not acting in their lawful duties, that they didn't have probable cause, and in the Brown case didn't even have reasonable suspicion, that there was a fatal flaw in those convictions, and so those convictions did need to be overturned. And that's what we're saying here in this case. There was a fatal flaw in the capias because there was no probable cause. The wiretapping charges were completely without probable cause because there was no expectation of privacy. And so because of that fatal flaw, those convictions should be overturned.
Let me ask a quick question. If an officer gets a call from Mr. Waite and the officer says, "I'm sorry, I'm not going to have a conversation with you, sir, if you record it."
Yes.
What happens then?
Well, Your Honor, I think we go back to the reasonable expectation of privacy. At that point, the officer has expressed that he expects privacy in, hypothetically, in that instance, it might be put the onus on Mr. Waite to then say, "I am going to be recording you." But that's not the facts of our case.
But there's no right of a citizen to have the conversation recorded with a police officer in all circumstances.
I think to that point, then, it has to be one that society would be willing to recognize. And I think that when we get into a fact issue like that, where you have that kind of situation, that is something that potentially would need to go to a jury. However, in our case, we don't have that. The facts are undisputed. We have the situation where the state has agreed that they were acting in their official capacity and also agreed that they never expressed any sort of expectation of privacy as well. And so based upon the reasonable expectation of privacy that society would be willing to recognize, there was no expectation of privacy based upon that. Your Honors, if there's no other questions, I would reserve the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. I will start with a reasonable expectation of privacy. All of the cases finding that there is no reasonable expectation of privacy are public actions by law enforcement officers. Because the public has an interest in, there's no reason for an officer who's in a parking lot surrounded by people to say that he has an expectation of privacy. That's just not an objective, reasonable person. There are no cases finding that an officer has no expectation of privacy in a private one-on-one conversation. None, zero. Because the statute doesn't say that. The First Amendment doesn't require that. It's easy to think of this in a phone call. Well, people could be taping your calls, but the same rule would apply if somebody surreptitiously put a recorder in an officer's office and he's talking to an informant. That's a private one-on-one conversation in an office. He does not expect to be recorded. He has a reasonable expectation of privacy. That's what our Traverse said. That can't be allowed. That's law enforcement couldn't function in that situation.
Counsel, for confidential informants, aren't there exceptions for that already? It's clear that's different, is it not, than a conversation just in official capacity with a citizen?
What if a victim is talking to an officer in the privacy of an office? Is that he's doing he's acting in his official capacity? That can be surreptitiously recorded? It's not as offensive when the victim's doing it, right? But it's still, the rule is the rule. So you can put a recorder in an officer's private office, and every conversation he has no expectation of privacy, even though he doesn't know he's being recorded. That is not an objectively reasonable rule of law. It's certainly not required by the statute. That's why the statute says you have to have a subjective, objective, reasonable expectation of privacy.
How did any of these officers exhibit an expectation that the communication would not be intercepted?
Because they talked to them, they talked to the defendant one-on-one on a private cell phone or a private office phone. If they had been talking in a public place with him, there's no expectation of privacy. But nothing in the statute requires anybody to affirmatively say, I don't want you recording this conversation.
No, I understand that, but there's nothing in here as well that says you have to say, is it okay?
Right, you have to get consent.
Where does it say that in here?
That's what the statute is. It's an exception. You can record if you have consent.
Right, I understand that. But here, when it talks about an oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception.
Right.
Where does that come from here?
It comes from the fact that it is a private phone call on a private line.
Private? This is not, again, Judge Makar gave the hypothetical of, different public servants may have side jobs. They may do yard work or whatever. And if it's a yard work call and you're recording that, that's one thing. But when a citizen calls to make a complaint about police activity and the police call him back, that's not a private call, is it? That's a call in the official business.
It's official business, but it's still private because it's on a private cell phone or a private office phone that's not recorded, versus when somebody calls 911, they say right up front, this is going to be recorded. So there's no expectation of privacy by either party there. Party who walks into the police station and there's someone at the desk, there's no expectation of privacy here. It's like you'd walk into the clerk's office here. There's a bunch of people around. That's not going to be private. Person comes in and they go back to your chambers. That's a private conversation, unless your law clerk's in there or he brought his wife along, then it's not a private conversation. So that's where you get with McDonald, where it was in a private office, but there were a bunch of people there. That makes it, you have no reasonable expectation of privacy in those contexts. But it's when a one-on-one conversation, you have to allow officers to have private conversations with people or they can't do an investigation. They can't talk to a victim privately on their cell phone. If that cell phone could be recorded by someone, you're not going to get get the same honesty that's required to conduct the business of law enforcement. And again, the legislature could have put this exception in the statute. The legislature could have said any official business, you can be recorded. They could have made that one of the exceptions, and they chose not to. What they did instead is say you have to have this expectation of privacy so that public things that law enforcement officers do can be recorded. There's obviously a First Amendment interest in that, but that's not the same thing as a private conversation. Just because you're a law enforcement officer doesn't mean everything you do is subject to taping. It's not. You have an expectation of privacy in conversations with other officers, in conversations with victims.
But that's not what we're talking about. We're talking about official capacity. We're talking about somebody who is getting a return call about an officer complaint, right? So you keep talking about victims and confidential informants. That's not what we're talking about here, right?
But it's the same principle. Is every conversation that a police officer has in an official capacity private, automatically public? That's what the defendant is asking this court to find. No other court has ever found that. That's what he's asking for here. The statute doesn't say that. That's the rule that he wants here. And you can say, well, this guy, you know, he was complaining about a law enforcement officer. There's an exception in the statute that deals with that. If law enforcement is conducting an investigation, then that's a private conversation. And the legislature didn't write it so that if a citizen is making a complaint that could lead to an investigation, that can be recorded. I mean, the legislature has set out where this applies and where it doesn't. And this situation does not fall under the statute. He's arguing for a broad rule that basically says any official capacity conversation by a law enforcement officer there's no reasonable expectation of privacy. As a matter of law, that's what he's asking for. And you know, it might be, you think, well, this isn't such a bad thing in this case. Why is it any different if you're talking to a victim? Why is it any different if you're talking to a witness? Why is it any different if you're talking to an informant, unless there's a statute that specifically protects that? I'm not sure if there is or not.
Would that theory extend to judicial officers?
Pardon me?
Would the principle extend to judicial officers?
Why wouldn't it?
I'm not trying to open a can of worms. I'm just trying to figure out the
well,
parameters
if
of what
it's
we're
any
talking about.
public official in an official capacity, I would say, yeah, it probably could.
Well, we don't necessarily need to go there in this case because there at least is some evidence to suggest that there at least was a waiver or understanding among the officers that this individual was prone to recording conversations.
There was certainly a suspicion. Now, was there a suspicion back on the first charged call, which was the subject of the arrest warrant, which was in September of 2020? Sergeant Blair testified he had no idea it was being recalled. And more importantly, because this is a motion to dismiss, this isn't after a jury trial, the Traverse says they had no idea that this was being recorded. They had an expectation of privacy. It wasn't a recorded line. It was a private cell phone or a private office phone. That's what the Traverse says. So this isn't a case where factual disputes, you know, you get out of it. Go to trial. That's certainly an argument he could make at trial is, look, everybody knew this. He didn't really have an expectation of privacy. They're just harassing me. He could make that argument to a jury. Maybe they'd buy it. Maybe they didn't. But that's not the standard on a motion to dismiss. A motion to dismiss is if there's factual disputes on that, the state has the right to present its case to the jury. And that's what the trial court found here. He said that this was sufficiently traversed and the state has the right to go forward, so I'm denying the motion to dismiss. We're not in a situation where we're evaluating a bunch of facts. And this whole, you know, the warnings, there's a lot of dispute about that, about how they took those warnings. When you look at the phone calls themselves, you know, the officers were like, well, we suspected it, of course, because this guy seems to tape a lot of stuff. But he had warned me before. That's what Captain Glaze said. He warned me before when he was taping. He didn't warn me on the charge card, charged call. So I didn't think he was taping me. That's what he testified to. You know, that's what would be presented to a jury.
The initial call that he was charged on came about because he sent an email back in with a recording, correct?
Yes.
In other words, he was arrested for one call first,
right,
and then they found additional things on the recorder.
Yes, exactly.
The date of that call was what? Was that the January call?
That was let's see, September 2nd of 2020. That's the date of
That's the
that.
call he was arrested for.
That's,
The first call, the only one he was arrested for first.
you know, I'm
thought
wrong
that was
about
the
that.
January
Yes,
call.
I have a timeline here, because this is such a complicated case. The call he was arrested to was Sergeant Blair. That was in January 6th of 2021.
Right. I asked your opposing counsel, the 911 call where the operators, he said, I'm going to record the calls, and the operator said, that's okay. Was that January also, or do you know the date of that?
We
one?
don't, the transcript of that says the date is not, they don't know the date. There was a 911 call on January 6th, that first phone call, and the defendant says this call should be recorded. It was a 911 call. He was recording it. It was already recorded. That's what, Blair called him back on his private cell phone.
Right. And there's also discussion that Waite left a voicemail saying this call should be recorded or something to that extent, asking for a call back?
That was Vigiani, which was the first one that they didn't find out until it was provided in discovery. So they found out about that one late, which was why they amended the information to add that, even after all of this hearing and stuff took place. But we're not contesting that. Clearly, the parties intended to take care of all of these, and it's the same issue. So,
on
we're
page
not
8 of your
contesting that.
brief, you talk about the fact that Vigiano was never told by Captain Glaze that the defendant had told Glaze he was recording calls.
Right.
Okay. On transcript page 18, I'm sorry, record page 1852, there's a phone call made by Waite that Lieutenant Vigiano answers, and he says, this is Lieutenant Vigiano. The next thing is, Mr. Waite, yeah, I just want to let you know these calls are going to be recorded. So we have a decent conversation here, Lieutenant Vigiano. Then after that, the unidentified speaker, which turns out to be Captain Glaze, says, I wouldn't expect anything less. So Vigiano's either in on the call, and I know he was asked whether the captain puts it up to his ear, he uses a speakerphone. He said, I can't remember that particular time. I think he said usually he puts it up to his ear. But, I mean,
Right.
Vigiano's right there as part of the call, isn't he?
I think that I ran into that, and I thought, this doesn't make sense. I think that's a mistranscription, because this is during Glaze's testimony, and, you know, they're transcribing that phone call, and it says, you know, I think it's a misnomer. But it's very confusing. But when you look at the actual transcript of that call, I think that clarifies it. I'm sorry, this record is so huge, I didn't bring everything. But yeah, I remember, that was weird, but
Because it
Glaze
switches
testifies.
from identifying Lieutenant Vigiano, who then says, this is Lieutenant Vigiano,
Right, yes.
to, quote, unknown speaker, where it has
Yes.
to be clarified by the witness, that's Captain Glaze.
Right, that was confusing. I'm not exactly sure what happened there. And let me just say, this is a motion to dismiss. So that should be clarified at a jury trial. It's certainly not to the point that, because the state traversed this and said, I didn't know he was taping this call.
The trial judge excluded the proffers about the call being made. He called them hearsay and therefore excluded them. I think it was the judge, he or she, excluded them based on hearsay when they were being proffered or offered to show notice. And the notice doesn't, you know, and again, your opposing counsel, I think, made the point quite clearly, which is what I was thinking. It's not a matter of whether he was actually recording them. That's for the truth of the matter asserted.
Right.
I'm really, really recording them. It's just, you tell him you're recording, okay. If you really want it to be a private call after he says, I'm going to record these calls, you go, well, then I'm not going to talk to you, you don't have my permission, or turn it off. Whether they have the right to say that under the First Amendment's another question, but that's what they were offered for, and the judge said, I'm not going to consider that evidence.
Right, it was again, super long hearing. The whole thing was very confusing. It was excluded at one point. I could be wrong about this. I believe it was during the testimony of the defendant, but I could be wrong about that. And that would be self-serving hearsay, arguably. It's probably not.
Nothing self-serving
hearsay.
about, I'm
But-
recording this call.
Well, to come in through him, here's my bottom line. It didn't matter,
He
and here's
excluded
why.
the judge excluded the transcript proffers, not just the defendant's testimony. Said, how is that not hearsay?
Right.
And let the argument go forward, go, no.
Right.
That's
I have
hearsay.
two answers to that. Number one, it's a motion to dismiss. It doesn't matter, none of that stuff matters except the motion, the facts in the motion, and the facts in the traverse. So you don't have evidentiary hearings on motions to dismiss. That's number one. Number two, they came in anyway during the testimony of the officers. I don't know if that was at the second hearing and the judge didn't remember that ruling, but they came in anyways, and I cite that in my brief where all of these warnings came in. And because the officers explained why, that, again, they suspected he was taping, but they didn't know. And you have to, if you don't know, you have a reasonable expectation of privacy. On the motion to dismiss stage, that's what Sells and Edwards say. We're not going to allow them to dismiss this. Sure, they suspected in Edwards the guy was called into a meeting because he was taping other employees. So the supervisor was like, had a meeting with him, and they said, well, yeah, I suspected he was probably taping that too. The guy tapes everything. That's why they were talking to him. Edwards still says, but it's a motion to dismiss. And, that's certainly something you could argue to the jury, very persuasively perhaps, but that's not the standard on a motion to dismiss. So those are my arguments. They didn't need that testimony because it's a motion to dismiss, and it did come in anyways because all of these officers testified. And they asked them about the warnings, and they played the warnings. And, again, this would be a jury question whether somebody who's been told, that there's an email sent at some point, later on in this where they said, hey, guys, be careful. This guy's taping our phone calls.
Can I ask you,
That's pretty good evidence for a jury. It's not evidence on a motion to dismiss because a motion to dismiss isn't about evidence.
a quick evidentiary question? A, how were these recordings made? And B, were any of the conversations on either end on speakerphone?
The
Or with
Traverse,
third
the
parties.
state's Traverse says they were private cell phone conversations, one-on-one. That's what the Traverse says.
So it
Either
doesn't-
cell phone or on their office phone. So according to the state's Traverse, there were not other people there. If there would be other people there, I think you could have a solid argument. As a matter of law, there's no reasonable
Yeah,
expectation
other
of
people or
privacy.
speakerphone? Now, the first
Speakerphone if there's other people there. And again, that would get into the facts. How loud is your speakerphone? I mean, my coworkers, when they're on their speakerphone, I can hear them in my office. How loud is a speakerphone in this police officer's
Well, my
office?
first question was, how were they recorded? Was he putting himself on speakerphone and the call on speakerphone and then recording it that way?
The defendant, there's no testimony to that effect. There's certainly no testimony that the officers could tell he was on a speakerphone. And again, that's a pretty good argument. Well, obviously, they had no reasonable expectation of privacy. If this guy's on a speakerphone, you don't know who's on the phone call with him. There's obviously
But it was
more
attached,
than just him.
the one was attached to an email, so it was actually reduced to some sort of format that was...
Right.
Okay.
I'm not sure. So that's my argument as far as the reasonable expectation of privacy. This court would be an outlier if they found that every private conversation a police officer has there's no expectation of privacy. And that would be really, really troubling for the investigation of crimes. If legislature wanted to do that, they know how to do that. They have a bunch of exceptions in the statute. I would submit that is not something this court should do. There's certainly no other case law doing that. It's very different to have a private conversation with somebody one-on-one than to have a public arrest or a public conversation or a conversation at your front desk where there's a bunch of people around. That's a very different thing. As far as the Brady claim, if the state had taken a picture of the defendant and then destroyed it or lost it or hidden it, that's a Brady claim. This is a Trombetta claim. They didn't create the evidence. They had no reason to create that evidence. They didn't have the high resolution camera that the defendant's expert asked them to have. The defendant never said, my ribs hurt or I'm injured. They asked him if he wanted to go for medical care. He said no. They took a mug shot that captured the scratches on his face. And again, zero evidence in the record that he was kicked by anybody. They took him to the ground after he elbowed the officer in the face. Maybe that's how he hurt himself. Maybe he hurt himself afterwards. It's not a Brady matter. And as far as the arrest goes, you can't resist with violence, and you can't hit an officer even if it turns out later on the court finds that the arrest warrant was invalid, which is not the case here. We had a KPS. They relied on that in good faith. So we would ask the court to affirm. Thank you.
Your Honors, forgive me, I might jump around a little bit because I have my notes here, but I do want to make two important points here first. The issue here is not where they were recorded or how they were recorded. It is what they were doing. They were acting in their official capacity. That is what the state agreed to, and that is dispositive in this case. We don't need to get into the facts to figure out whether there was a reasonable expectation of privacy.
What about the parade of horribles that interviews with victims are in the official business, talking to a CI's official business? Where do you draw the line? You want us to write an opinion. How would we draw the line?
So, Your Honor, I would say there, first of all, we are not talking about a third party recording these conversations. And I would say that still the officers do not have a reasonable expectation of privacy, but the sexual assault victim or the confidential informant, they may have a reasonable expectation of privacy. The state even talked about if a sexual assault victim were to record their own conversation with a police officer. That's not so offensive. But reading it the way the state wants, the state could prosecute that victim for recording an officer. When an officer is operating in their official capacity, there is no reasonable expectation of privacy for that officer. And I think, too, as well, we look to the Sunshine Law, right? The Sunshine Law already has those expectations in place, or exceptions in place, that those are public documents, but they're not disclosable under those circumstances. So those are the first 2 points that I just wanted to bring out. I think, as well, the state had mentioned that there was an expectation of privacy in the Traverse, but the Traverse admitted that the officers never expressed that expectation of privacy to Mr. Waite, and that is part of that subjective expectation. It can't be something that you just hold in your head. It has to be expressed in some way. And I think, to Judge Makar, to your point, the judicial officers, I think we look there to the Sunshine Law as well. The Sunshine Law does talk about certain judicial documents and those kinds of things as being accepted from disclosure. And I think, too, we go to the Sells and Edwards cases, and those are about whether a suspicion is enough. In our case, we're not talking about a suspicion. Okay, the fellow officer rule automatically imputes that knowledge to every other officer. So once he informed, and I'm going to just go through the timeline here, on September 2020, Sergeant Vigiano, Mr. Waite, told him that he had collected the 911 calls as well, the recorded 911 calls as well. And then in October...
That doesn't tell Vigiano that he's recorded, correct?
I think that it leaves it open that...
But I mean, he's saying, I know the 911 calls are recorded, I've got copies of them, period.
Yes. Well, he says as well, in addition to other calls potentially. And I understand, but I think we go then to Sergeant Vigiano and Captain Glaze. That's October of 2020. And he very explicitly said he is recording all calls there. And I think that this is the one that you were talking about where it's not clear who was... It was Sergeant Vigiano and Captain Glaze, according to the transcript. And then the Sergeant Blair call was January 6th of 2021. And that was in response to a voicemail that he left on that same day. And so just based on that, we have there that these officers, you impute that knowledge that any one of them has to all of the others that are part of the investigation. And I understand that, you know, we don't really need to go to the facts there, but I do want to make sure that the record is clear and that it is clear what order things had happened in. And I think that, the state talks about how these facts are not important because we're talking about a C4 motion here, but I do think it is important because there's more than one motion here, right? We're talking about a C4 motion, multiple motions to dismiss, motion to suppress, and so it is important in the case of determining whether there were omissions. And that was the point when we talked about the hearsay issues, saying that this is important because the judge did not have the information he needed to know whether there had been omissions to create probable cause, or that those omissions would have defeated probable cause. And so they are important in that way. And lastly, I would get to the duty to preserve here, and the state mentioned the Trombetta case. And the Trombetta case there, it didn't really rest on this duty to preserve. What the Supreme Court of the United States ultimately had there was that you have to know that it is material before it is, in this case it was destroyed, but we're talking about that failure to preserve. We know that it was material because the state's case for the battery on a law enforcement officer and the resisting with violence charges, that rested entirely on the deputy's testimony. And where it does rest entirely on the testimony, the Mordenti case specifically says that that is material. So we knew before it was ever lost that it was material. And it wasn't just the officers. Later when he went to the jail, he did express that he was hurt. And the jail failed to take any photos there, failed to send him for x-rays, and so the state failed its duty. It is the state's duty to preserve evidence. It is not Mr. Waite's. And so that failure is a violation of Brady. And so, Your Honors, we would ask that you reverse all of the charges for the multiple violations of Mr. Waite's due process and other rights in this case. Thank you very much.
All right, thank you. Well argued by both sides, and as soon as we will be in recess. All rise.